Okay.
Okay. So the agenda is the same as last time. Um, Opening statements by the appellant and then the respondent. The appellant can reserve time, 10 minutes each. Then I've done a random selection. The order, the random order was is I came up with here is Krawchuk, Seebeck, me, Montoni, Kinsella, Stratton, and Latham. But Stratton's not going to be here. I don't know if Montoni's going to be here. So that's the order. And then there'll be 5 minutes of rebuttal by each of the litigants. Appellant going first, respondent going second, and then another round of questioning by the Judicial Committee if they so desire.
Mr. Chair, could you repeat that order, please?
Repeat the order. Krawchuk,
Yep.
Seebeck,
Yep.
Arnoff, Montoni, Kinsella, Stratton, and Latham.
Got it. Thank you.
Okay. Okay. So if let me ask the parties if everybody is present whom they want to be present. Mr. Appellant, that would be, I guess, Mr. McGee.
That's Mr. Campbell.
I'm sorry, you're right, Mr. Campbell. Mr. Campbell, is everyone you need present?
Yeah, I'm here.
Okay, and the same for you, Mr. McGee?
Mr. McGee is here.
Okay, if you have everybody here you need, then Mr. Campbell, please go ahead. You have 10 minutes opening statement, and you can reserve time to rebut if you like.
Thank you. Members of the Judicial Committee, first of all, thank you for your service. Over the course of this term, you have been asked to review a significant number of difficult and often contentious disputes. This case may well be the final appeal before the upcoming National Convention, and it presents an opportunity to provide clear ruling on an issue that has recurred throughout this term. You now have the benefit not only of the parties' briefs, but also two amicus filings, one by Karen Ann Harlos and one Hector Roos, which frame the competing interpretations of the LNC's authority and the procedural requirements at issue. This case asks a fundamental question. Can the LNC impose discipline without calling it discipline and avoid the rules that discipline requires? But before reaching that question, there's a simpler one that may resolve the case entirely. Was there valid notice of the June 9th meeting at all? The LNC called a special meeting on June 2nd to adopt the SIC report. But at that moment, the SIC report did not exist. It would not exist until the SIC met on June 7th. The report was then provided less than 48 hours before the June 9th meeting. This is not just a timing issue. It is a notice failure at its core, because notice requires informing members what they're being asked to consider. And here, the answer is unavoidable. How can notice be valid when the thing being noticed does not yet exist? I would invite the respondent to answer that question directly, because if the answer is that notice was still valid, then notice no longer requires content, only a placeholder. And that is not consistent with Robert's rules or basic principles of deliberative governance. The issue was not emphasized in the initial petition, but was developed in the reply once the record was clear. June 2nd, meeting called. June 7th, report created. Less than 48 hours, time for review. But more fundamentally, the notice was incomplete at the moment it was given. But importantly, the LNC itself recognized a notice defect. It voided its own June 9th resolutions. That alone provides a clear and narrow basis for this committee to act. If the committee wishes, it can resolve this case on that ground alone. Insufficient notice. That is a straightforward, well-established basis to void LNC actions without reaching the broader disciplinary question. But even if the committee does reach that question, the answer is the same. The SIC process investigated alleged misconduct, made findings, declared an individual unfit, and imposed consequences. That is discipline in substance. And it was not done without charges, without notice of disciplinary notice, without hearing. Sorry, it was done, pardon me. The amicus filings illustrated this clearly, using prior LNC examples that the SIC departed from the standard by, taking actions that were not expressly authorized in the motion that created the SIC, such as making recommendations, adjudicating misconduct, and defining it in terms of violations of law, suggested disciplinary measures that consisted of real consequences and not merely opinion. So the committee is presented with two paths. The narrow path, invalidate the action for lack of notice. The broader path, recognize that discipline occurred without due process. Either path leads to the same result. Under the bylaws, the policy manual, and Robert's rules, these actions cannot stand, and they must be declared null and void. Thank you. I reserve my remaining time for rebuttal.
Okay, you used about 4.5 minutes. Mr. McGee, your opening statement.
Thank you. Members of the National Judicial Committee. The LNC respectfully submits this statement in response to the petition before you. The statement is provided to outline the factual background, committee actions, adopted resolutions, and to address the petitioner's claims regarding disciplinary standards, notice requirements, and due process as established by the party's bylaws, the policy manual, and Robert's Rules of Order. The purpose is to ensure an accurate account of the proceedings and to demonstrate the LNC's commitment to procedural integrity in all its actions. This is the third time that this matter has come before you, so I won't belabor the factual background, except to emphasize the relevant factual background for this case. The formal disciplinary process for Angela McArdle began on January 23rd, 2025, when the LNC opened an email ballot to form a formal disciplinary investigatory committee. The proposed committee was tasked with investigating the allegations of misconduct against Ms. McArdle. Just 2 days later, on January 25th, Ms. McArdle submitted her formal resignation as chair of the Libertarian Party, a move that significantly shifted the priority of the National Committee's focus. On January the 30th, the original motion to create the Disciplinary Investigatory Committee passed unanimously by a vote of 14-0-0-2 not voting. However, on the meeting of February the 2nd, 2025, the LNC recognized the need for a separate inquiry and established a special investigatory committee to examine issues involving conflict of interest and business practices within the committee itself. Shortly thereafter, on February the 10th, a new email ballot was opened proposing to discharge the original disciplinary investigatory committee, arguing its purpose was now moot given that both McArdle's resignation and the establishment of the SIC, the motion passed on February 17th, again by unanimous vote, this time 13 votes for not voting, effectively closing the original disciplinary inquiry and handing all investigative responsibilities to the SIC. As for the argument from the petitioner that the report did not exist at the time that the meeting was called on June the 2nd, that is not true. The report existed, it just had not been approved. There's an important distinction there. You can't just generate a 100-page report in a couple days. It doesn't happen. The conclusions were already there. It was just a matter of getting the committee members together to adopt it, which they did. All right. So the argument put forth by the petitioner is contingent on the disciplinary and substance standard of discipline. Without it, the entire argument fails. In essence, the argument of the petitioner is that anything disciplinary in substance is in fact disciplinary action under the bylaws, policy manual, and RONR. As such, anything determined to be disciplinary in substance requires disciplinary notice, charges, and fair procedure. Applied to this situation at hand, the argument is that the SIC report and its pertinent resolutions were disciplinary in substance, and thus their adoptions were disciplinary actions requiring disciplinary notice, charges, and fair procedure. The thesis of the disciplinary in substance standard is set forth by the petitioner is that discipline is determined by substance, not label. The implication is that the National Committee is using mere semantic labels to get around disciplinary requirements. By implication, the petitioner is manufacturing the intent of the committee. Discipline is determined by procedural instrument, not by a vague notion of substance. RONR provides specifically for disciplinary and non-disciplinary actions. The National Committee has adhered faithfully to using the correct procedural instrument. While Mr. McArdle was on the National Committee, the priority was to pursue disciplinary action. Once Ms. McArdle resigned, that priority explicitly shifted. The SIC report, however harsh, is not the same thing as disciplinary action. It is merely the sincere report of the committee members who spent months trying to get to the bottom of the situation. At the heart of this appeal is the fact that the National Committee acted within its authority by investigating matters under its jurisdiction and adopting resolutions that express its findings and opinions. After Ms. McArdle's resignation, the LNC received the SIC report and passed resolutions stating that her conduct fell below the party's expected standards. Importantly, these resolutions did not impose any formal disciplinary sanctions such as suspension or expulsion, nor did they revoke any member rights that would trigger a disciplinary process under the bylaws, the policy manual, or Robert's Rules of Order. The petitioner's characterization of the LNC's actions as disciplinary in substance is imprecise and rhetorical. Ironically, terms like de facto penalties, functional disqualification, and repackaged discipline are mere flourish without meaningful substance. The petitioner further mischaracterizes the LNC response to manufacture a concession. In Section 7 of the petitioner's reply, the petitioner asserts that the LNC admits uncertainty regarding what protections apply to members and quotes a truncated fragment. It is unclear whether a general member of the party would be entitled to the same member rights. This is misleading and a misleading presentation of the record. The full quote in context reads, based on the argument provided by the petitioner, it is unclear whether a general member of the party would be entitled to the same member rights and disciplinary procedures as National Committee members. These rules. It was demonstrating the vagueness and impracticality of the petitioner's own disciplinary and substance framework. The petitioner's selective quotation distorts the National Committee's criticism into an admission. No such concession was offered. Relevant precedents such as Phillies v. LNC and Harlos are distinct from the current situation. In those cases, disciplinary processes and member removal was central, whereas in McArdle's case, she had already resigned and the LNC's resolution served only to record its conclusions about past events and issue a non-disciplinary censure. Therefore, the factual and procedural contexts are materially different, supporting the LNC's position that its actions did not constitute disciplinary measures requiring formal procedures. If the Judicial Committee were to accept the petitioner's vague disciplinary and substance standard, the National Committee would be hamstrung in its ability to address or even comment on conduct it finds concerning, unless it initiated a formal disciplinary trial. Since the LNC does not have the authority to impose formal discipline on party members, that's a power reserved specifically for National Convention delegates, this standard would force the LNC into silence whenever it discovers potential wrongdoing among National Committee members. Members that, I remind you, are charged while in office to uphold fiduciary duty to the party. Such an unreasonable standard would not only restrict the expression rights of the party's elected leaders, but also violate the LNC's governing rules, as it would prevent them from even voicing their opinions or findings in response to misconduct. The LNC has a fiduciary duty to safeguard the party's reputation, finances, and integrity. Under the petitioner's framework, the LNC faces a no-win scenario. If it investigates and expresses concern, it risks being accused of imposing de facto discipline without due process. If it remains silent, it fails in its obligation to the party's membership. Historically, the LNC has published negative reports and issued censures, such as in the cases involving former Chair Joe Bishop Henchman and Assemblyman John Moore, without these actions being considered disciplinary in substance or requiring formal trials. These precedents illustrate that strong expressions of opinion or findings have not previously been treated as disciplinary actions necessitating procedural safeguards. In conclusion, the LNC asserts that its actions following Ms. McCardle's resignation, specifically the SIC investigation and its resolutions, were permissible expressions of opinion and not formal disciplinary measures. The petitioners claim that these actions were disciplinary in substance and thus required no discharges and due process under party rules is challenged, with the LNC emphasizing its adherence to proper procedural instruments and distinguishing its actions from disciplinary precedents. The LNC argues that accepting the petitioner's vague standard would restrict its ability to fulfill fiduciary duties and express concerns about misconduct, ultimately undermining the committee's governance and integrity. Past cases, including negative reports and censures, demonstrate that strong opinions or findings have not been treated as disciplinary actions requiring formal procedures, supporting the LNC's position in this appeal. I welcome the questions of the committee.
Okay, thank you, Mr. McGee. Mr. Campbell, do you have a reply?
Yes, thank you. I don't think that it is without substance that the SIC findings were punitive in nature. Things like censures are punitive and they require formal hearings. And notice for that is really important, especially where the subject of the hearing is really important, because maybe that changes maybe the respondent's strategy with how they respond to such things, if they even show up in the first place and answer questions on something, because maybe they had information on a specific case that they would really like to have shared. So I don't think it is without substance to say that there wasn't a substantive need for due process. It's substantive because the findings were punitive in nature. It is procedurally flawed because of the fact that it was without notice. So substantively, she should have been given notice of what to respond to, and procedurally, the notice itself is necessary within the bylaws. So that's just what I want to clear up. Thank you. I yield my remaining time.
Okay, thank you, Mr. Campbell. Questions by the Judicial Committee. First up, Mr. Krawchuk. Mr. Krawchuk, you appear to be muted or something. Can't hear you. Cannot hear you, Mr. Krawchuk. Okay, Mr. Krawchuk appears to be having some kind of technical difficulty. Let's move on to Mr. Seebeck, and we'll come back to Mr. Krawchuk.
All righty. These are questions primarily from Mr. Campbell. First question, how and where does Roberts define an original main motion?
An original main motion?
An original main motion.
I mean, I can start going through the contents here and start looking for that, but I don't know the Robert's rules that well back off the top of my head.
It's in 10.3 where it indicates that a main motion introduces a substantive question on a new subject. So how does Roberts define an incidental main motion?
I mean, again, that's getting I'm not an expert on Robert's rules.
This goes towards notice, sir.
Right.
10.4 indicates that a main motion is incidental to or relates to the business of the assembly or its past or future action. The recommendations from the SIC, were they original main motions or incidental main motions, and why?
I would say it'd be an original main motion because it's bringing a new subject before the assembly of consideration.
Except for the fact that the subject was brought forth to the committee for consideration when they voted to establish the SIC in the first place. And for Roberts 10.5, an incidental main motion involving a subject already introduced might include a motion to adopt recommendations which a committee has prepared upon instructions. And that's in 10.5. What's the policy manual say about original main motions?
I think a big piece of this hinges on the fact that the respondent even said the goal of this shifted from when she resigned to being more disciplinary in nature. So it's really just a matter of timing here.
That's not answering the question. What does the policy manual say about it? About the notice for original main motions?
The policy manual says that that original main motions require previous notice.
Correct. What does it say about incidental main motions?
I don't think they say anything.
Exactly. They don't. So this was an incidental main motion to adopt the report. Therefore, notice, according to the policy manual, wasn't required. So where would notice be covered on this then?
The SIC report was an original main motion because it departed from its original authorization.
Did it? Because the original motion had to do with establishment of the SIC to examine issues of ethics and practices of the actual entire LNC. And they did that because the report also included information regarding a couple other LNC members, including Mr. Ford. The actual application for notice is in Roberts 915, and that's where it says that notice is included in call of the meeting, but it doesn't preclude the consideration of privileged motions or any specific incidental or other motions that may arise in connection with the transaction of such business or the conduct of the meeting. And that this requirement, this is 916, that business transacted at a special meeting be specified in the call should not be confused with the requirement that previous notice of a motion be given. Although the call of a special meeting must state the purpose of the meeting, it doesn't need to give the exact content of individual motions to be considered. When a main motion related to business is specified in the call of a special meeting is pending, it is fully open to germane amendments as if it had been moved at a regular meeting. So again, what does Roberts say for notice from incidental main motions? It's in 1047. Unless the rules require full text of a motion, a resolution, or bylaw amendment be submitted within the notice, only the purport need to be indicated, which is a statement of purport must be accurate and complete.
Right. But the original notice was for investigations, not for discipline.
Did not the committee do investigations?
They did investigations and then discipline.
No, they did not. They recommended things. They did not impose anything. And as a nature of the committee, it is their job to make recommendations or to propose resolutions. They proposed recommendations for which the LNC acted on. And that was crystal clear in the wording of the SIC itself. Because here's a simple question about it. Okay. If the report called them recommendations, are they original main motions or are they incidentals again? And again, this goes back to notice.
I think just substantively, really what I want to hammer here is that the motion to adopt the SIC report was an original main motion because it departed from its original authorization.
It actually didn't. But 1047 specifically says that incidental main motions have specific notice applications, and the question is, were those met? Because they were 7 days in advance of the call in the meeting. I would say the answer to that is yes. Does a censure require disciplinary procedures? Mr. Campbell, you're muted.
Sorry, thank you. Not if the censure were the only option. Or sorry, opinion.
Okay, and what's the basis for that for that possibility?
I'm sorry, you mean like the basis of the censure?
No, you said it doesn't have to be, it wouldn't need disciplinary procedures if there were other options besides censure, if I heard you correctly.
I think it just depends on the content of the censure.
All righty. Roberts 39.7, it touches on this very clearly. It says, except as may be necessary in the case of a motion of censure or a motion related to a disciplinary procedures, a motion must not use language flex on the member's conduct or character, et cetera, and so on. Also, 61.2 footnote 1, which I know that Mr. McGee mentioned in his LNC response, it's also possible to adopt a motion censure without formal disciplinary procedures, which is what happened in this case. So here's the next question. What happened to Joshua Smith in 2022?
I'm sure you can bring up something relevant.
He was
I'm sure
censured by the LNC without a disciplinary process.
I'm sorry?
He was censored by the LNC without a disciplinary process. Some of the current members of the LNC are still there when that happened. So there is precedent, not requiring a disciplinary process. Did Ms. McArdle resign prior to the SIC report being adopted?
Right. And then the focus of the SIC shifted, as was stated earlier. And the motion of censure can express opinion, but once it says that a disciplinary conclusion does it trigger due process protections.
Was McArdle still on the LNC at the time that the recommendations were adopted?
No.
Then what due process requirements or the bylaws and the policy manual came into play?
Check my notes. Are you asking for like what rule?
Yes. If the allegation is they violated the rule, then it needs to be a citation of the rule they violated.
Second. I think I'm looking at the due process protections under Robert's rules, the rule for censures. Hold on.
Except we've already covered that, and I asked about the policy manual of the bylaws.
I'm sorry.
Except I asked about the bylaws and the policy manual, not Roberts. Roberts we already covered with 61.2 footnote 1.
Right. So you want me to, I don't know. I can't find it in my notes right now. In the policy manual
or the bylaws,
for the bylaws,
or both.
I mean, if it's not covered, hold on, I'm just looking. If it's not covered, it would have to revert to Robert's rules. Hold on. Article 7, sections 5 through 6, and the bylaws article under 16, and policy manual subsections 101.4, 107.2 through 5. Under the Libertarian Party bylaws, special rules of order, and the party's adopted parliamentarian authority, disciplinary actions include censure, suspension, expulsion, and other sanctions that formally condemn a member's conduct or restrict a participation or eligibility.
But does that discount the ability under Roberts to have a disciplinary or a censure without a disciplinary process? Because it's already been done before by the LNC, multiple cases. And if they already can do it,
Yes.
then how is that exceeding their authority?
I don't think so. This is through the bylaws, and a lot of the things here are essential for substantive and procedural due process. That being a procedural right, and there just simply wasn't the same proper notice because of the subject of the SIC. And it's the rules to protect the members. Joshua Smith didn't complain about his censure, or just because Joshua Smith didn't complain about his censure doesn't mean that it justifies the action here.
Maybe it does, maybe it doesn't. Let me ask you one more question. Where do you think I got all these questions from?
No idea.
My previous opinion in this case, specifically paragraphs 41 through 68. It's a good idea when you guys do your research on these cases, if there's a previous opinion or opinions, that you read them, because you might find that what's already there already answers your questions. That's all from me, Mr. Chair.
Okay, thank you, Mr. Stiebeck. Mr. Krawchuk, have you fixed your technical issue?
Maybe yes, maybe no. Can you hear me?
We can hear you.
I can hear you.
All right. Well, it's half fixed. I don't have video. I only have audio. All right. Close enough. You won't see me making faces at you. Okay. Mr. Campbell, just a question. Did you write that appeal?
By myself, no, I had a lot of help, but I put it all together. Just needed help with like the bylaws and stuff like that. But yeah, I wrote it.
Okay. Well, regarding the bylaws, outside of a convention, what is the authority of the Judicial Committee?
I'm sorry?
Outside of a convention, what is the authority of the Judicial Committee? What can we do?
I think you guys can do a lot of power. I mean, you guys have a lot of power here. You can follow whatever policy you guys want to present here. I mean, you guys have a lot of power.
Well, what actions can we perform?
I mean, specific, it's hard to enumerate line item by line item. Is like, are you looking under the bylaws? Like, because I mean, what we're looking for is voiding the action of the LNC that violate the bylaws.
Okay. All right, because outside of a convention, that's pretty much all we can do is to nullify a decision of the LNC. I have in front of me your prayer for relief, the things that you wanted to. Number one, declaratory relief. Declare that the challenge actions were disciplinary in substance. Sir, we don't do that. We don't give any kind of declarations or anything. We only nullify decisions of the LNC or not.
Mhm.
Which is why I was asking why was that in there?
I mean, maybe a Hail Mary. This is something that I feel is necessary to hash out here with the JC because, I mean, if the JC is looking at, just with doubling down on prior readings, whatever, you can do that. Or you can look at the fact that this is just a procedure, a due process issue that is like really the crux of what bylaws are supposed to do. We're supposed to play all by the same rules. And if the first notice that was given is about investigatory committees and then actual discipline in substance was handed down and a potential respondent wasn't given the kind of notice that maybe, hey, you should come look at this. I think it's really important to have some sort of opinion. I guess like some sort of opinion that procedure will be followed, and that could be like administrative.
Okay, it's beyond our authority to just go and declare stuff like that. We can choose to veto something, and internally we may discuss something like that, but it's outside the scope of our powers. Next one, number 2 and number 3, a partial veto and full veto. Again, what we do is we will nullify decisions of the LNC. I did not see the decisions listed in your appeal. I checked out the footnotes, and there are all kinds of motions that are in there. Some of them seem germane, some of them didn't. Are we supposed to pick and choose which ones we nullify? Why did I miss seeing the list of what you want, specifically what you want it nullified?
I'm sorry, where are you looking?
Well, I'm still under your remedies requested, numbers 2 and 3, a partial veto and a full veto of those resolutions or directives that purport to impose disciplinary action. And again, my statement is when I went through your appeal, I did not find a list of those decisions that you want nullified. And I went, and you had a bibliography there at the end with all the different minutes and everything. I went and looked at them, and there were a lot of decisions in there. And
Right.
I really came away saying, which one should we nullify? Are we supposed to guess? Do we pick and choose? How are we supposed to know what to nullify?
I'm looking at the relief requested right now.
I'm sorry, I cannot hear you.
I'm looking at it right now. Petitioners respectfully request that the Judicial Committee grant such relief as to the adoption of the Special Investigatory Committee report and all actions taken thereupon by the Libertarian National Committee at its June 9th, 2025 special meeting. The new SIC-related resolutions from August 24th, 2025, and any later actions that rely on these actions made before any ruling on this matter as it deems appropriate, including one or more of the following. That's under section 7.
Uh-huh. Okay.
It's just
Still seems a bit vague. Again, I was looking for something substantive. Here's the list of things that we thought was wrong.
No, I mean, I'm not looking to down any hills. Any relief that the Judicial Committee can give us, really. I mean, If you're telling me that's something that the JC can't do, then I'm not here to try to die on that hill. But if you're saying that
Well, again,
avoiding the decision, then I would like that, yes.
okay, but we only would nullify decisions. And again, I didn't see a list, only a general statement of anything that may or may not have applied. And I'm not smart enough to pick out all those things that you feel are important. I might wind up picking out things that I think are important that you wouldn't. So I just didn't see that list. Moving on to number 4, perspective clarification. Perspective guidance. Again, we don't do perspective guidance. We look at everything fresh. And that's another thing. You refer back to some of the prior decisions, and Mr. Seebeck was correct. You can go back there and look for guidance on things that he has said before, but every one of these is brand new. There's no prior history. There's no any kind of precedent that we are required to follow. So again, you're asking for things that we don't do. And when you get to number 5, other relief, grant other and further relief. That sounds like something an attorney wrote. Are you an attorney?
I'm an attorney, yes.
Okay, it shows.
Sorry, I
All
wasn't
right.
trying to.
Well, that's it.
Oh, sorry. No, go ahead.
I know, because again, it seems like you did not read the section of our bylaws about what the Judicial Committee does, because all this is just, it's vague. It's stuff we don't do.
Yeah, I mean,
And,
the hill that I
you know-
want to down is that the notice is voidable. That's the crux of why I'm here today.
Well, whether or not it is or isn't, we only have the power to say that. All right, I think I'm done. It's just that I just didn't have enough information to do anything. And just to let you know, when it first came in, I thought it just wasn't sufficient enough, detailed enough for an appeal.
I think,
And I would have the
right. I think it's just important to say any action taken by the LNC based on insufficient notice is voidable. That's what's being asked. It's a lot of actions. That is true. Yes. But yeah, that's what we want.
Okay. All right. Well, thank you very much for the answers, sir.
Of course.
Okay, thank you, Mr. Krawchuk. I'm up next, and as long as we were talking about the notice before, I'll start with that. I basically have 4 points that I want to investigate. I think implicit in what Mr. Seebeck was asking is that there's a difference between prior notice and notice for the call of a special meeting. I'm not sure if there's any it seemed that you were trying to say that there should have been prior notice, but I think Mr. Seebeck is probably correct that that this was incidental. I mean, the LNC created an SIC. The SIC came in. The SIC was producing a report. I don't think any prior notice was necessary to consider the report, but there is notice that is required in the call of a meeting. I mean, a special meeting. I think Mr. Seebeck may have read this, but let me just read it again. This is from Roberts 916. The requirement that business transacted at a special meeting be specified in the call should not be confused with the requirement that previous notice of a motion be given. Okay, so I don't think that the previous notice was necessary, but the call of the meeting has to have, I mean, what the business that's transacted at a special meeting has to be within the notice. So my first question is, I think it, let's see, where was it? Respondents, in respondents in the respondent's brief, where is it? Page 8, I believe. It says that the full text of the motions of censure were provided in the call of the August 24th special meeting. Mr. Campbell, do you know if that's true?
I'm sorry, page 8 of the respondents.
Of the respondent's brief, Theo Campbell respondent's brief, page 8. It says here, it's the second to last paragraph before the conclusion. Regarding the ultimately adopted resolutions, right, and these are the resolutions regarding the alleged wrongdoing by Ms. McCardle. The full text of the resolutions was provided at the call to the August 24th special meeting in Chair Nikhil's response to Mr. Bowler's point of order. Do you dispute that? Or do you admit that the text of the resolutions that were adopted at the August 24th meeting were in the call of the meeting?
I'm sorry, if I may ask to clarify, dispute what specifically?
This statement in respondent's brief. Respondent is alleging here that the full text of the resolutions that were voted on the August 24th meeting were in the call of the meeting, right? At the August 24th meeting, resolutions were passed, this is my wording, condemning certain actions by Ms. McCardle. Those resolutions were voted on at that meeting. Was the full text of those resolutions provided in the call for the meeting?
I dispute that the disciplinary nature of the report was disclosed, or that the disciplinary nature of the report was disclosed. Like,
I'm not talking about
the disciplinary in substance.
I'm not talking about the report. I'm talking about the motions that were voted on. The report was adopted in the June 9th meeting, correct?
The motions were voided by point of order.
In the June 9th meeting.
Yes.
Okay. What about the August 24th meeting? Was there another meeting? Was there a second meeting on August 24th?
Yes.
And at that meeting, were those same motions that were voided in the June 9th meeting, were those same motions again put forward in the August 24th meeting?
They were not the same motions, but
They were
depending
not.
on the report.
The motions censuring Ms. McCardle. You're saying there were no motions censuring Ms. McCardle in the August 24th meeting?
I'm saying, am I saying that I'm saying that or not saying that?
Mr. McGee, maybe you can help us out here. Were there motions passed censuring Ms. McCardle at the August 24th meeting?
Yes, there were. There were two. While the wording may not have been the exact same as the ones passed the June 9th meeting, they were resolutions similar in nature, but with different wording.
Yeah, right. I agree. They did censure, but not in the same way. Thank you.
Okay. Were the motions that were passed at the August 24th meeting, was the precise text of those motions specified in the call of the meeting?
Yes.
Mr. P.
Yes, absolutely. Specifically in response to Mr. Bowler. In fact, I posted that in my factual background in my brief. If you scroll back up to pages 3 and 4 of my brief, you can see the exact wording of Mr. Nikhila in response to Mr. Bowler. and the full text of both resolutions is present.
Okay, Mr. Campbell, do you agree that the full text of the motions that were passed, and by the way, Mr. McGee, those motions were passed at the August 24th meeting, is that correct?
That is correct, sir.
Okay, so Mr. Campbell, do you agree that the motions that were passed at the August 24th meeting, that the text of those motions was provided in the call of the August 24th meeting? You concede that, or do you dispute that?
Let me look at my notes here. I mean, if you want me to look at that right now, yeah, hold on. Sorry.
You know, it's all right. Let me just ask you this. Would you concede that there is no failure of notice if the text of those motions that were passed at the August 24th meeting were in the call of the August 24th meeting? Follow that?
If they were in the call of the August 24th meeting?
Yes, I mean, this is a factual question. Either the text of the motions that were passed at the August 24th meeting were in the call of the August 24th meeting, or they were not in the call. Would you concede that if they were in the call of the August 24th meeting, that notice was satisfied? Or do you think there is some other basis for questioning the notice in this case?
The August 24th resolutions were in the call of the meeting, but they can be voidable still.
On what basis?
The SIC report adoption failed the notice requirement, ergo, any action dependent on the SIC report is also voidable.
Well, okay.
If I may read the resolution.
I mean, I'm not sure that's true. I mean, if you're saying that they have to, that without the SIC report, there's no, they can't, that the LNC can't pass a motion of censure?
I think they skipped a step in doing what they did here.
Okay, well, let me ask this then. Do you think that that these motions of censure should have had a full trial?
Yes,
trial. You hold that
yes.
that a trial was required in this case.
Yes. Yes.
So based on that, so basically you're that they can't pass these motions of censure without a full trial.
Well, so we're talking about the August 24th resolutions. If I just may read them into the record here.
If you like.
Resolution 1, whereas the Special Investigatory Committee has found that former Chair Angela McArdle engaged in actions that, in the LNC's view, violated fiduciary duties to the Libertarian Party, including concealing conflicts of interest and misusing donor funds. Now, therefore, it be resolved that the Libertarian National Committee censures Angela McArdle for conduct in violation of the fiduciary duties and ethical standards expected of party leaders. Be it further resolved that the Libertarian National Committee expresses its opinion that Angela McArdle's conduct, as detailed in the Special Investigatory Report, reflects behavior inconsistent with the standards expected of those serving in leadership roles of the Libertarian Party or as a candidate representing it. Resolution 2, whereas the Special Investigatory Committee finds that former Chair Angela McArdle financially benefited from her deception of the Libertarian National Committee, be it resolved that the Libertarian National Committee shall explore fundraising and or pro bono legal counsel to pursue the recovery of funds under any legal procedures available as outlined in this report and any supplemental reports produced by the Special Investigatory Committee.
All right. I was just only trying to deal with the the notice issue. You've brought up another issue, which is a reasonable issue, as to what steps are required to make a censure like this.
Right.
But in terms of just plain notice, can we dispense with the notice issue and say that there is no failure of notice here? Because I think there's also a second. Not only was the in terms of these motions of censure, not only was the text of the motions provided in the call of the meeting, but the fact that the report was passed at the June 9th meeting, and maybe that shouldn't have been passed at the June 9th meeting, but the fact that these motions were made in response to this, pertinent to this report. Now, I kind of agree with you that was somewhat of an ambush, right? You don't call a special meeting and say, hey, we're going to consider this report, and then put these draconian motions of censure on the table. You have to specify that in the call of the meeting. That's not what the meeting is called for. The meeting was not called for a disciplinary purpose. The meeting was called for the purpose of considering the report, and then these disciplinary things were sprung on everybody. But given that happened the first time, and then those two resolutions were rescinded, and then they were repeated. I mean, you had the same thing happen again at the August 24th meeting, where they said we're going to consider this report, and then they sprung these two resolutions. Arguably, isn't just the mere fact that the same thing happened a month earlier, doesn't that really give you notice that this is what's planning to happen? I mean, even beside the fact that the actual text of the motions was in the call of the meeting, even without that, I think you'd have notice of what was going to happen, right? So, can we dispense with the issue of notice?
The August 24th resolutions were in the call of the meeting, but they can be voidable because it's dependent on the SIC report, which is adopted improperly. So yes.
What's that got to do with notice?
It's the subject of the notice itself.
Okay, so okay, I'm going to take that as that you admit that there is no notice issue.
The notice issue of the SIC report can void actions later.
Well, obviously, you're saying there's a procedural problem. I'm just saying there is no procedural problem. There is no notice issue. The text of the first meeting, the June 9th meeting, there was notice of the report, right? We're going to consider this report. There's no notice issue. Everybody knew that that a report was created. Everybody knew that the SIC itself was created, and that the SIC had a report, and everybody's expecting the fact that they're going to consider a report. That is fine notice, I would think. I don't see what the problem is. Isn't if you say we're going to consider the SIC report, even if the report hasn't been created yet, the SIC report is, you can even say it, the SIC report, which hasn't been created yet, it's going to be available in a couple of days. We're going to be considering adopting that report at the next meeting. Is there something wrong with that notice?
That the report hasn't even been created yet?
Yeah, if you say we're going to be created, the report's going to be created. It's going to be created 2 days before the meeting, and at this meeting we're going to be considering adoption of the report. Is there a problem with that?
Right. Well, the SIC report wasn't published indicate that it was a valid report under the motion that created the SIC.
I'm sorry, I didn't follow that. Could you say that again?
I'm sorry, it's a departure from the instructions. The SIC report wasn't published to indicate that it was a valid report under the motion that created the SIC. That made it an original main motion.
Right. I'm just talking about the call of the meeting. All right. A meeting is called saying, we're going to consider this SIC report. And then at the meeting, they adopted the SIC report. It seems to me that there's no issue of notice there. There may be other issues, but there's no issue of notice. You're saying we're going to adopt this report. The report comes in, you adopt the report. Then you also go on to create resolutions that are disciplinary in nature. That's a problem. Okay. But those were rescinded. And then those were dealt with later. And in the later meeting, there is no problem of notice, because the first meeting, you have noticed that this is what happened in the first meeting, so you know it's going to happen again in the second meeting. And to really put this to bed, the text of the resolutions is provided in the call of the second meeting. So can we admit that there's no notice issue?
I think that's a different
other issues, but not notice.
Right. I think that I understand what you're saying. I think that's a different notice standard than what is suggested by the respondent to apply. I believe we're looking at in the policy manual 1.02. The call violated the previous notice requirement in 1.02 of the policy manual.
Okay. I'll call your attention again to Roberts 916. The requirement that business transacted at a special meeting be specified in the call should not be confused with a requirement that previous notice of a motion be given. Those are two different types of notice. I don't believe that there was any necessity for
I think I understand
previous notice of these motions.
Right. Well, so I mean, Robert's rules is available for when we don't have any idea what to do here through LNC or whoever or bylaws, but this is cleared up in the policy manual,
right?
Which supersedes Robert's in this moment because we have clarification from.
Okay, I'd like to move on. I think you're not applying the rules properly. The previous notice is not really at issue when you're talking about a special meeting. That's only, it says that that previous notice is necessary if the rules require it. There's no rule requiring previous notice for these things. So that also, doesn't.
Sorry.
Okay, I'm going to move on. I spent way more time on this than I wanted to.
Yeah, of course.
Let's talk for a minute about discipline. I guess this is for Mr. McGee. Would you say? Do you think can you really say with a straight face that these censure motions are not disciplinary?
In the context of Roberts, yeah.
Yes.
There's a very specific distinction between what a disciplinary process is and what it isn't. There again, if we were talking about the only reason this is even an issue is because there are two different types of censure allowed in Roberts, which makes it censure unique when it comes to any sort of disciplinary or non-disciplinary type of procedure. Obviously, if these resolutions had attempted to expel or suspend Ms. McCardle from the LNC, that obviously would require a disciplinary process. And certainly one of the penalties after a disciplinary trial is a disciplinary censure. But there is clear distinction, as outlined by Mr. Seebeck and in my respondent brief, between a motion of censure and a disciplinary censure. And I would argue that just because that doesn't make it disciplinary.
You haven't even. This is news to me. You know, I don't pretend to know every single thing about Roberts, but was not aware that there are two different types of censure in Roberts. Do you have any kind of a cite for that?
Mr. Seebeck cited, I believe it's 39.7, and certainly I cited in my brief 61.2 footnote 1.
Okay, well, in 61.2, outside of footnote 1, it says punishments that a society can impose generally fall under the headings of censure, fine, if authorized in the bylaws, suspension, or expulsion.
Right.
So,
which I also
censure
outlined.
is a punishment. Censure is a punishment, is it not?
In a disciplinary context, it is.
So there are kinds of censure that are not disciplinary?
Right, because well, okay, to go back to the example, I believe it was the question asked by Mr. Seebeck, if are there any provisions in the bylaws for, disciplinary action? And Mr. Campbell correctly cited several bylaws that do apply to relevant disciplinary action. However, the disciplinary action provided for in the bylaws only applies to LNC members. Once Ms. McCardle resigned, those regulations no longer become relevant, because there's no way that the LNC can actually pursue discipline against someone that is not a member of the LNC per the bylaws. And so the LNC's action was not in pursuit of that. It's a motion to censure, whereas a disciplinary censure can only apply to members of a specific body that is authorized for discipline, here being the LNC. A motion to censure can be against anyone. For example, the LNC could pass a motion to censure Donald Trump for starting for the war in Iran if they wanted to. Is that disciplinary in nature? I mean, is that really a credible argument?
Could the LNC censure a regular member of the party?
They could pass a motion of censure, but they could not use a disciplinary censure.
Where do you see a distinction between disciplinary censure and non-disciplinary censure in Roberts or in the bylaws or anywhere else?
It's pretty clear from 39.7, because there is a distinguishment between. Let me pull up 39.7 for you just to try and make this clear. Okay, so 39.7. No motion can be introduced that is outside the object of the society as defined in the corporate charter, constitution, or bylaws, unless by 2/3 vote, the assembly agrees to it in case of a motion of censure, or a motion related to disciplinary procedures. A motion must not use language that reflects on a member's conduct or character, or is discourteous, unnecessarily harsh, or not allowed in debate. So this is a specific carve-out in Roberts for motions of censure that is distinct from disciplinary censure as laid out in section 61.
So you think that the LNC would have the authority to censure a member of the party who is not a member of the LNC?
A motion of censure. There's no grounds for the LNC being able to actually pass disciplinary censure. Disciplinary censure is distinct from a motion of censure because it does require a disciplinary process under Runner 60, Section 63, as I outlined in my respondent brief.
All right. So you maintain that there are two different kinds of censure: a disciplinary censure and a non-disciplinary censure.
Correct.
Okay. Oh, that's interesting. I never heard of that, but something I'll have to look into. Okay. So I have two other points, questions. I guess this is for Mr. Campbell. Did you have a chance to look at Ms. Harlow's amicus brief, Mr. Campbell?
Very briefly.
Well, she made some actual good points about bringing up. Would you say that this case is any different from the last case? I mean, how is this case? Are the facts in this case any different from the last one we decided? I mean, in other words, does it make sense for the JC to allow the same case to come before it again and again and again?
Are we saying that the disciplinary actions have any teeth or no teeth? Then I feel like.
What, you want to go back to the previous discussion?
Well, I mean, is this real or is this not? Are there any teeth to this action? If Angela came back tomorrow, joined the LNC, would there be any repercussions from this? The facts are different between my appeal brief and
but I don't know. I'm not. That's not really not a question that's being posed here. So I'm not sure.
The facts are different between my appeal brief and my reply brief. It asks for different relief than past cases.
No, I'm saying that there was a case. Roos brought the same. Mr. Roos brought the same case to us a few months ago, and now it's before us again. Why weren't the arguments that you're making today brought up during the Roos appeal?
Why was my later writings different from my earlier?
Why didn't you bring these arguments up? You made an appeal recently, right? This appeal that we're hearing today. Why did you not bring these arguments up when Roos made his appeal?
I think that's probably a question for Mr. Roos.
No, it's a question for you. Why didn't you say, I see Mr. Roos is making this appeal. I have some issues about this too. Let me join Mr. Roos in his appeal, or let me file an amicus brief or something. Why did you wait until the Roos appeal was decided, and now you're bringing a new appeal based on exactly the same facts? Why did you mention these facts last time we considered these facts? Right? Have the facts changed?
So it sounds like the question is, why did I bring up an appeal that wasn't available yet? Right? Until
you're an attorney? You're an attorney, Mr. Campbell?
Yes.
Are you familiar with the concept of res judicata or claim preclusion, res judicata? You familiar with that concept?
Yeah.
Okay. The idea is that you don't get two bites at the apple normally, right? In a real court, and I concede this is not a real court, you make your best case. You have to bring forward all your arguments. You can't keep a bunch of arguments in reserve, and then ask for the court to hear it again, right? You have to put all your arguments in, and once the court has decided, you got to make your best arguments. and all your arguments. And once the court has made a decision, you can't 6 months later come back and say, hey, I want to have another trial based on the same facts. Isn't that what you're doing here?
I mean, no, but also the LNC is governed by the bylaws and the rules. If you're asking about res judicata, I mean, we got to talk about parties and facts, and I mean, if you want to apply like a legal standard, that's one thing, but we're talking about bylaws here.
What we're talking about here is a factual situation. People, Mr. Roos and others, did not like the fact that these resolutions were passed and that this report was passed, and he brought a case to void these resolutions. Now, 6 months later, you're bringing exactly the same facts to us, but with a different theory, a different legal theory.
Right.
Should that be allowed? Would that?
If you're saying that it's a different
doesn't that open? Yeah. I'm sorry?
If you're saying we're talking about a different legal theory, yes, and also the facts are not all the same. I mean,
they're not. What facts are different? There was an SIC report passed on the 9th. You feel that on June 9th, you feel that SIC report was should not have been passed for, right? And you wanted that Mr. Roos wanted that SIC report voided, and
I don't think
resolutions of censure were passed on August 24th, and Mr. Roos wanted those voided. Aren't you asking for exactly the same thing, or it's based on the same factual scenario?
I'm not sure his mentions the call of the June 9th and notice issues.
The notice issue is your legal theory. It has nothing to do with the facts. The facts haven't changed. Whatever notice there was then, it's the same notice now. There's no new discovery of a notice that people didn't know about.
I think if this were to happen again, even with the same everything and everybody's, if this were a new thing that
what were to happen again? I don't understand.
Like
another trial based on the third trial based on the same facts, or
yeah, I think if there was a third time that this happens again, where they say they're going to, like the notice given was that they're going to consider an investigatory report, and then they made the decision to adopt the investigatory report.
You're not addressing my question. Am I correct? You're saying if the LNC does the same thing again in some future case that they did now, what will we do in that case? Is that what you're saying? I'm saying this is the second time this case is brought before us. Is there any reason why we should even entertain this case? We've already heard this case. These same exact facts came before us 6 months ago. Why should we hear exactly the same things again? Exactly the same facts. We've already heard these facts. Why would we listen to these facts again?
I think this one thing was obviously highly contentious, and it's going to rustle a lot of jimmies. And I think there's a lot of different ways to look at this one thing that happened. I mean, there's different variables to this one end conclusion. So
you're saying that here in the Libertarian Party, people should get two bites at the apple, as they say. You should get, if you bring a case before the Judicial Committee and you say, I don't like what the LNC did, I'm going to bring this case. If you don't get the answer you like, if the Judicial Committee rules for the LNC, then you could just come back again 6 months later or 4 months later or the next day and again say, Judicial Committee, we want you to hear this case again.
I think
you can just keep doing that and doing that until we find in your favor, maybe just to make you go away. But once we find in the appellant's favor, the LNC can't really appeal. So, I mean, isn't this just a way to if we allow you to prosecute this appeal, which is based on exactly the same facts that were prosecuted 6 months ago, doesn't that open the door to perpetual appeal after appeal after appeal of the same issue until?
No. To answer your question, we're not
until you win.
We're not litigating the facts here. The difference here, I mean, like, to answer your question, like, something can happen. You get arrested for, I don't know, burglary, but they decide, oh, on these facts, it's actually assaults and robbery. What, you know what I mean? Yeah, that can happen. And the JC didn't grant relief to Roos because he didn't ask for it. I don't, correct me if I'm wrong, but he didn't talk about the notice issue or the disciplinary nature of the actions.
I believe he did. He had a whole thing about misrepresentation and everything. Yeah, he all of that stuff was brought up, but it's not the point. What arguments were made is not the point. The point is that we've already had a trial on this fact pattern, on these facts. Facts haven't changed, right? This is all stuff that happened in the past. The past doesn't change. Not in, maybe in communist countries the past changes, but not here. So, the question is, once you've had a trial, let's say, I don't want to cast any aspersions on anybody, but let's take a hypothetical. You have a trial based on facts, and the prosecutor does a lousy job. Okay, you don't get a great trial. Okay, and you lose. Should you be able to then bring it back and say, let's try it again?
If you didn't get notice of the trial, then yeah, you got to have proper notice.
Oh, you got notice of the trial.
Well, that depends. If you're having a trial on an assault,
you're saying you didn't get notice that there was a trial?
You got to have notice of what the substance of the trial is. If you get a summons and it's like, hey, you're looking at simple theft, but actually they hear robbery charges at that trial, that's not the same thing.
Let's not talk about a criminal case. Let's talk about you see your neighbor steal your lawnmower out of your yard, so you sue your neighbor, and you have a crappy attorney, and the judge says, nope, he didn't steal your lawnmower. Should you be able to bring the trial again with a new attorney and a new theory and say, hey, he stole my lawnmower? Should you be able to go back to court and say, or should the guy say, look, you've wasted enough of my time, okay? We had this trial, and it was found that I didn't steal his lawnmower, so why do I have to come back to court and defend myself again? Do you think you should be able to bring that same case twice?
I think if we're talking about lawnmowers here, if the reason is it wasn't his lawnmower and it's someone else's lawnmower, that guy could say, hey, yeah, actually, I want to sue this guy, though.
Well, let's say the court just made a mistake. They were wrong. It was your lawnmower, and the guy stole your lawnmower, but your attorney was an idiot, and he didn't ask the right questions or whatever. And now you've got a better attorney who's going to ask the right questions. Should you be able to bring the case again?
Notice actually can overthrow an entire case. Notice is a very, very important fundamental.
I didn't mention anything about notice. I didn't mention notice.
This
okay. There's a. Let me ask Mr. McGee. Is the LNC concerned at all about this issue that of somebody bringing the same case over and over again based on the same facts, or are they not concerned with that? I mean, I could see maybe you say, well, it's not going to happen. It's probably never happened before. It's happening in this case because some issues were not brought up that could have been, you know, and so this is a special case. This isn't going to happen all the time, and we don't care, you know, or you may feel differently. Has the LNC considered this issue at all?
Actually, yes. And this is technically the first time that a case has been brought based on the same facts.
Okay. And what
certainly they've been changed. Where for example, in the case originally, Harlos won the challenge to the JFC, and then Mr. DeRazio's later challenge once circumstances regarding RFK changed. They're not the exact same facts, so you can't say that we're retrying the same thing because the fact patterns are not the same. In this case, the fact patterns are the same. The only thing that's different is the legal theory.
That's right. And so what's wrong with that? So what? So they can bring, it's a different legal theory. Better, you know, we made a mistake in the first case. We did not get justice. You know, we need justice. So we're bringing this case again because we didn't get justice the first time. Something wrong with that?
Yes.
What?
It creates.
Mr. Chair, pardon me if I break in here. Let's stop talking about foreign bylaws, foreign rules. It doesn't matter what other courts do. The question is, what does Roberts say? What do our bylaws say? What does the policy manual say? Can you please abandon this line of discussion?
Pardon.
This is an issue regarding the propriety of bringing the same case over and over again to the Mr. Krawczyk, you're saying that there is no basis for questioning this? There's no issue of basic fairness or wasting the time of the Judicial Committee and the LNC over and over again? That there's no concern that the same case may be brought over and over again?
I beg your pardon.
Sir, I said at the beginning, you should not have accepted this appeal. You should not have accepted it.
I beg your pardon, Mr. Tarnoff, or Chair Tarnoff. I think perhaps Mr. Krawczyk only has about another half hour that he's available, and I think that may be why, you know, he's not inclined to continue this line of questioning.
All right, I'm gonna. Who said that? Mr. McGee? Okay, I'm gonna move on to my last issue, if I can remember it. Yes, I would call your attention to is it 63.3? Is that it? Yes, 63.3 of Roberts, where it says, if after a trial a member is expelled or an officer is removed from office, the society has the right to disclose that fact, circulating it only to the extent required for the protection of the society or possibly of other organizations. And here's the important sentence. Neither the society nor any of its members has the right to make public the charge of which an officer or member has been found guilty, or to reveal any other details connected with the case. My question is I guess I have several questions. Has the SIC report been made public?
It has.
To the entire world, or just to the LP membership?
My understanding is it's public.
Public. And what about the motions of censure, the 2 or 3, I forget how many there were, motions of censure describing pretty serious allegations against Ms. McCardle? Have those also been made public?
I mean, they're in the minutes.
They're in the minutes, and anyone in the world can look at those minutes.
They're on the lp.org. Yes. The short answer is yes.
Okay, so what would you say about this second sentence here in 63.3? Neither the society nor any of its members has the right to make public the charge of which an officer or member has been found guilty, or to reveal any other details connected with the case.
This
Don't you
presupposes
feel that you have violated that by publicizing these very serious charges against Ms. McCardle?
Again, this presupposes, in fact, Ronner 63 entirely presupposes disciplinary action. As I've already outlined to you, these motions of censure do not constitute disciplinary action and therefore not subject to Ronner 63.
Well, do these motions constitute a finding by the LNC of wrongdoing on the part of Ms. McCardle?
They constitute an opinion based on a special investigation by an ad hoc committee, neither of which constitutes disciplinary action.
Well, disciplinary action or not, okay. Would you concede that if these statements regarding what Ms. McCardle allegedly did, or that the LNC believes she did, that if these are not true, they would be defamatory?
Absolutely. But Roberts allows motions to be in order that are potentially defamatory. If you look at actually, if you look at, in fact, this is actually mentioned by Mr. Jacobs in Jacobs v. LNC, his initial petition. He concedes that a original main motion can't be ruled out of order just because it's potentially libelous. I believe it's actually the 1026.
Oh, that's interesting. That's probably true. Let's see, 1026. You know, I mean, yes, a body has the right to do things that are illegal or defamatory, but it just says here that neither the society or any of its members has the right to make public the charge of it. I mean, if after a trial and a person has been found guilty of something, you can't reveal what they did, why can you reveal what they did without a trial?
Well, that has to do with the actual Ronner 63 process as a whole. In general, if you read if you understand the disciplinary process, the actual act of preferring charges or forming a committee to investigate, a disciplinary investigatory committee, is supposed to be, per Ronner, done in executive session so as to not expose a society to potential legal liability. However, our bylaws, specifically Article 715, precludes us from being able to make any such decision in executive session. Therefore, our bylaws necessarily preclude us from being able to protect our society from legal liability through a disciplinary investigatory committee.
Let's say Ms. McCardle had a trial,
yes,
right, and was found guilty of these charges. You're saying, and these motions, and the penalty was going to be these motions of censure, the exact same motions that were passed. Are you saying that those motions could be ruled out of order because of 63.3, but the fact that she didn't have a trial means that the motions cannot be ruled out of order? Could those motions be ruled out of order? If she had a trial per Section 63 and the penalty imposed was these exact motions of censure, could those be ruled out of order?
Under our current bylaws, no.
They could not.
But that has nothing to do with Ronner. If our bylaws didn't interfere or supersede that provision in Ronner, you would hypothetically be correct. But that's not the way 715 reads. We're not allowed to make any decisions, any sort of decisions like applying a penalty. That's why in the trial of Karen Ann Harlos, while this body ultimately ruled it out of order or overturned the decision of the LNC in that trial, the fact of the matter is that because of the bylaws, the actual charges, as well as the ultimate vote to suspend Ms. Harlos, was required to be done in open session, therefore making it public, therefore making it in violation of Honor 63.3. So that's just our bylaws. That's a particular quirk of our bylaws.
Okay, so you're all right. Yeah, all right. I guess that's a reasonable point. But let me ask you a hypothetical. If we were to find that the LNC improperly publicized facts about Ms. Harlos, about Ms. McCardle, beyond the fact, there's no question the LNC has the absolute right to say Ms. McCardle is something like, Ms. McCardle has been censured for inappropriate activity as chair or improper financial whatever, something vague like that. But if the Judicial Committee were to find that the way these motions are worded, that it was not proper for the LNC to release that information to the public, what would be an appropriate remedy for that?
That's a vague hypothetical. It depends on what the basis for the JC ruling that is.
Would it make sense for the JC to, since there really is no other way to do it, to say that the motions are overturned because this information should not have been made public? Is there a reason that wouldn't make sense?
I would respectfully disagree because of the arguments made here and in my responded brief, but certainly that's the purview of the JC.
Okay, I'm done. Is Mr. Montoni here? Did Mr. Montoni ever come?
He has not.
I don't believe he is. Okay. Mr. Kinsella.
Yeah. I have nothing much to add. Your questions are really good along the line of res judicata. I guess I would just comment that I personally don't think it's appropriate for the JC to admonish members for knowing something about the law. And furthermore, I guess one JC member's opinion that there's no res judicata doesn't mean we're all bound by that. We have different opinions about how to rule according to justice and interpreting the bylaws. So that's all I'd say there.
Okay. I believe Mr. Stratton is not here. Mr. Latham, do you have any questions?
I do not for this round, Mr. Chairman.
Okay, well, that concludes the questioning by the Judicial Committee. The litigants now will have 5 minutes each for rebuttal, beginning with Mr. Campbell.
Thank you. I think just overarching, just to kind of answer a lot of the lines of questioning, this is a Judicial Committee that is hearing this based off of the bylaws and justice. Under the bylaws, I'm looking at Policy Manual 1.02.1. One, previous notice, an LNC member may satisfy the requirement of giving previous notice of their intention to introduce an original main motion at the next session by announcing this intention at the previous session in the presence of a quorum, providing an accurate and complete statement of purport with such notice to be taken note of the minutes, or sending the complete language of the motion to the entire LNC by email at least 5 days prior to the session. This being an original main motion because under Robert's Rules 1052, the motion to adopt the SIC report was an original main motion and subject to previous notice under the policy manual 1.021, because under 1052, a motion to adopt or accept a report or the recommendations of a standing committee prepared on the committee's own initiative and dealing with a subject that was not expressly referred to the committee, however, is an original main motion. Now, at the close of this case, the issues are, I hope, clearer and narrower than they first appeared. You have before you not only the parties' arguments, but also two amicus briefs that sharpen the dispute. But despite that volume of argument, one question remains unanswered. How can notice be valid when the subject of the meeting did not exist at the time of the notice was given? The timeline is undisputed. June 2, meeting called. June 7, report created. Less than 48 hours provided to members. That is not meaningful notice. That is not an adequate preparation. That is not in compliance with the Libertarian Party's rules or values. And that alone is sufficient. The committee does not need to resolve every ambiguity raised in the briefs. It can decide that this case is on the clearest grounds available. The June 9 meeting was improperly noticed. The LNC itself recognized this problem. It voided its own resolutions. That is not a technical defect. That is an acknowledgement that the process failed. If the committee chooses that path, the outcome is straightforward. The actions are void for lack of notice. But even if the committee looked beyond notice, the same result follows. The SIC process investigated, found misconduct, declared unfitness, and imposed consequences. That is discipline. And yet, no charges, no notice, no hearing. The respondent and the Harlow's amicus attempt to rely on ambiguity, but ambiguity cannot eliminate rights. It must be resolved in favor of protecting them. And the examples discussed in the amicus filings confirm the line. LPNH, investigation without discipline. Moore, opinion without discipline. SIC, discipline without process. Ultimately, the committee does not need to choose between these theories. It can choose clarity. It can choose the simplest and strongest ground. The notice was insufficient. And if the committee wishes to go further, the record supports that as well. Under Article 7, Section 12, if an LNC action if an LNC action contravenes the bylaws, it must be declared null and void. Here, the notice was defective. The process was deficient, and the result is clear. These actions must be declared null and void. Also, I hope this helps too, but let's see. A point of order on the same continuing breach may be raised at different sessions. That is the standard of why appeals on the same or similar facts can be brought. The JC accepted a second appeal on the JFC, and at least asking for consistency is requested. Thank you.
Okay, thank you. Mr. McGee, your rebuttal. Mr. McGee?
Sorry. I would like to note for the record that this is the third time I've had to deal with the misreading of section 1.02.1. Again, this is the third time that the appellant has conveniently discontinued their reading of that section before getting to the very last part. Previous notice is not required unless specified by the party bylaws or its parliamentary authority, though vote thresholds may change based upon whether or not notice was given. And the only provisions in Ronner for previous notice pertains to bylaws amendments and amendments to special rules of order. These resolutions were neither. Therefore, previous notice does not apply. As for the argument that the LNC conceded that their motions were out of order. If you read the response to Mr. Bowler, Mr. Nikela makes it very clear that the reason why he's ruling the previous resolutions out of order is for procedural clarity, not because he's conceding that the content was inappropriate. Furthermore, actually, that really is the primary basis of my response. The notice issue is non-existent. As stated in my opening statement, this is all contingent on the disciplinary standard of disciplinary in substance, which fundamentally misunderstands the difference between disciplinary censure and motions of censure. If this standard is not accepted, all of the questions of notice are irrelevant because no disciplinary notice is required. Thank you.
Okay, thank you. Do any of the JC members wish to ask further questions? Mr. Krawchuk?
I am clear, sir. Thank you for everything.
Mr. Seebeck?
Yes, I have one last question. This is for both Mr. McGee and Mr. Campbell. Is the LNC expressing an opinion by resolution a disciplinary procedure?
No.
I'm sorry, what was the question?
Is the LNC expressing an opinion by a resolution a disciplinary procedure or action?
Only if it's limited to opinion.
That's all I have.
Okay, I have no further questions. I assume Mr. Montani is still not here. Mr. Kinsella? Mr. Kinsella still here? Mr. Kinsella, are you muted? I'll come back to Mr. Kinsella. Mr. Stratton, I believe, is still not here. Mr. Latham, do you have any questions on this round?
Yeah, let me ask this, and I'll just say that as an attorney, I think the res judicata concept is interesting. I just unfortunately think our bylaws and rules currently do not allow it. It would be interesting maybe to construct a rule. Maybe we need to raise the petition threshold for these kinds of things. I think of someone who's a party member who may want to bring up an issue to the Judicial Committee, and they have to confront this kind of very confusing legal doctrine that could be arbitrarily kind of invoked, where a Judicial Committee, maybe not all the members are law trained, say, it kind of smells like what we did earlier, so we're not going to this time. So I think it's interesting to ponder, but it actually does get me to another legal concept, but hopefully it's I'll express it or put it out there in a way that is understandable to the layperson. So, Mr. Campbell, are you familiar as an attorney with the concept of harmless error?
I would need more context on contractually, judicially.
And maybe you're muted.
Oh, can you hear me now?
Okay. And I don't mean to play gotcha like I think some of these questions have been. Yeah, I heard you, and I heard you say no on harmless error. And kind of the concept is, even if everything you say is true, so what? And the reason I kind of put that out there is I'm looking at Mr. Jacobs' brief, and in some ways he raised a lot of the same issues that your petition raises, but then there was this agreement, and he drew a petition, and then the LNC did some different things. They, I guess, changed the text of their resolutions, but there was, language, I think, in Mr. Jacobs' petition, that was supported by some others, just talking about, gosh, had there been sufficient notice, more people could have lobbied the LNC, and maybe there would have been a different result. So, but that's missing from your petition. So when you're talking so much about notice, I guess I'm trying to figure out how was the petitioners, the signatories to your petition, how was anyone prejudiced by, I think what everybody admits was there in the LNC to consider it and then passing the resolutions they passed. Is my question kind of clear there? So I
Yeah.
think of the concept as harmless error, but a layperson might, so what?
I mean, so harmless error, there's different factions of belief of harm, well, not belief, application of harmless error. I mean, if you're talking contractual versus judicial, this being the judicial committee, if we're gonna go to where are we land, a harmless error would actually be a great reason to overturn a decision. So like if
Okay,
there's like
unpack
a
that.
application
If it's harmless, why would we
or not harmless, if there's a
disturb a
wrong
decision that's
application of
harmless?
if there's a wrong application of law, it would be retried. And if it's off of like the judicial, like they would be allowed to remand it. If there was something that's important to fix for like the case law. Does that make sense? It's like they might remand something really quick.
Well, it does, but I don't think you're grokking the concept of harmless. If nothing changes, if nobody was harmed by the say inappropriate notice problem,
Define harm though. I mean,
then why do this again?
Define harmed though. She was named in
Say
right? Wasn't that part of the
but she
testimony given is
but
that she was
okay.
mentioned on the
But
website
let's
for
assume that Ms. McCardle knew that.
Sorry, Mr. Latham, I think you're cutting out for at least me.
I think the point is,
Sorry, man.
your petition tries to. Oh, maybe it's me. Is anyone else? Am I cutting out for anybody else?
Yes, you're cutting out for me too.
Mr. Chairman, thumbs down. Who's cutting out? Is it me or is it?
It seems to be you.
Bummer. Well, okay. Boy, I'm wired in and everything, so I apologize. Is this any better?
It sounds better so far. Yes.
Testing. 1, 2, 3.
Can you hear me? Am I okay?
All right.
I hear everything you're saying now.
I can hear you great. Thank you. Okay, sorry, and I am getting that notice off and on that says the connection's unstable. So, I think where again the harm, what prevented Ms. McCardle or others in support of her cause of their August action?
Well, I guess if they knew better what they were actually going to be doing, if they're just considering the investigatory report, okay, you guys can talk about this. But if they're giving notice that they're going to adopt the special can't talk. We're 2 hours in this investigatory committee report, that's a different conversation. I could see wanting to skip out on, we're going to talk about it to we're going to adopt it. Those are two different things.
Well, what about the resolutions? I mean, the resolutions were out there in June, and there were just slightly different resolutions in August. So, I mean, again, how was one side prejudiced?
the threshold matter here is when we get
Because I think in Mr.
from.
Jacobs,
Oh, go ahead. Sorry.
no, I think that's what the question in harmless error is kind of does an error substantially influence the fairness of a proceeding? And so I just, come back to the question of how, maybe that was the case when Mr. Jacobs filed his petition, but then, the problem was addressed by the LNC, and so a month and a half goes by, and then the LNC has issued a notice of concern.
I'm sorry. Are you asking? I'm sorry. What are you asking?
Yeah. So why you're saying if notice is bad, then everything that comes after it is bad.
Right.
But again, the concept in harmless error is okay. So what? Um, uh, it's not now just a 2 day gap; it's a month and a half gap. And I mean, are you claiming that people were surprised as to what happened in August?
I don't want to talk about what people be surprised in hearing about. I just think that if the notice were different, maybe there would be an actual quote unquote trial where the parties could be present to hear from the witnesses and examine and cross-examine if we're talking trials. I know this is much more informal, but I mean,
Okay. Well, but you're assuming it's problematic if there was a trial. I Of course there was not a trial, and I think the LNC's position is that this kind of censure is not deserving of a trial. So just, regular non-disciplinary censure. Um, what's the harm in the month and a half notice?
so my my perspective here is that the LNC didn't commit a harmless error. There was harm to members, that being plural. And the LNC makeup changed between February, June, and August. But what that doesn't mean that doesn't mean that they can continue business based on actions that were improperly noticed or were improperly disciplinary matters.
Okay, I'm still maybe I'll come back to you. I think I want to hear from Mr. McGee on this question. Is it proper for this judicial committee to kind of consider the so what question um, on notice? What was any kind of notice problem that might have existed in June have been fixed in August, and why is that? If so, why is that?
When you say, so what, could you explain to me the reasoning again? Because I wasn't quite following earlier because your audio was a little bit choppy.
Except in the law called harmless error, but I think a layperson is so what? And so I think the petitioner here is just saying there was a notice problem in June, and so that you know taints everything that follows it. It's a continuing breach, they might say. But practically speaking, the harmless error analysis is okay, even if that was an error, um, did that affect the fairness of the proceeding? And so that's kind of what I'm getting at is what was the harm, even if there was some kind of error in notice that happened in June? Does that error is that error cured in some way by things that happen, later, the notice of the meeting for August and then the August meeting?
Um, I think with respect to the resolutions, I think the August 24th meeting was sufficient to cure any potential issues. Again, while the LNC did not concede that there were uh, substantial issues. If there were, I would argue certainly that the meeting of August 24th, where the new resolutions were adopted, certainly cured any potential defects in the original resolutions.
And just, I get that's your argument. I guess I want to have a little support for that. Is there something in our, bylaws or parliamentary authority that helps us answer that question? And maybe if it's just, I'll get that if this is kind of a new hitting you cold for the first time, that may be a research project for us. But if I think that would be helpful for us to mull.
I guess in order to answer that question, I would need to better. I'm not quite sure I understand what you're asking, because it sounds like, okay, even if there was an issue with notice, sort of a sort of a if no one was hurt, so what? It sounds like that. Am I
Exactly.
mischaracter?
Yeah.
Okay.
No, I think that's a good way of framing it. Because this August 24th meeting, I mean, I'm sure I could probably find it in the materials, but you know off the top of your head how much of a time gap took place between, was there a meeting August 24th and there was probably a call of the meeting before that?
The call of the meeting was on August 10th. It's in my respondent brief.
So man, 2 weeks. And of course that follows a prior meeting in June. So that's my, you know, is it okay for this judicial committee to say, even if things were problematic in June, people had plenty of notice of what was coming down the pike for the August 24th meeting because
Sorry,
of
my
the
bad. My bad.
August 10th.
I just looked at it August 18th. My bad.
Okay, well, so 6 days. Um, eh, but same question. So I mean, is there a so what argument to be made here? And if so, what's the authority support or against that? Maybe I'm confusing. There's a problem in bringing legal concepts into kind of a parliamentary bylaws kind of question. Maybe they're not applicable.
And I think I think that's exactly where, at least currently, where you're hitting the nail on the head here. There are a number of legal concepts that, while valid in a court of law, don't necessarily pertain to the bylaws, the LNC special rules of order or parliamentary procedure as outlined in Roberts. And I know that's a disconnect that a lot of people have had to struggle with, myself included. But I think there is a fair argument as to whether or not there should be provisions, somewhere either in the bylaws or in special rules where some of those concepts are introduced in order to prevent confusion like this in the future. Um, I would say at this point in time, it's probably going to be a matter for a future LNC. But what I will say is that, I I understand where you're coming from, and I think there's definitely potential for addressing that in the future.
Okay. Thank you for indulging me, Mr. McGee and Mr. Campbell. I'll just come back to you now that maybe you've had a chance to chew on this question. Are you able to kind of give me any support one way or the other on how the folks, you and the folks in support of your petition, um, you know, can show that there was a harm in notice that you're challenging in June for things that ended up happening in August, late August.
Right. I think as a baseline, we are correct to, recenter here that this is not a court of laws. Questions were asked with that framing in mind, but really, this is the Judicial Committee for the Libertarian Party. And we're looking at what the bylaws say. I would say, as an aside, we're really worried about harm still because there is potentially some harm that could be defined within the bylaws. And the SIC report also targeted other members too. But I think procedurally, motions to ratify is how the Roberts rule, that's a Roberts rules mechanism to fix notice issues. The LNC, if I'm not mistaken, didn't ratify the motion to adopt the SIC report. This was an issue in June, and the LNC didn't try to fix it if it was fixable. I hope that does that answer your question?
I'm going to chew on it as well. So thanks for your reply, Mr. Campbell and Mr. Chairman. I think that concludes my questioning. Thanks.
Okay, Mr. Latham. Well, we still have Mr. Kinsella if he's available. Mr. Kinsella, are you there?
Yeah, I'm here. I don't have anything further. Thank you.
Okay, well, I guess that concludes the hearing. Thank you, everybody.